authorise.
My Lord, yes. There should be before you two documents, one of which is the consultation paper, which I think my Lord Master of Laws did not have, made with Lord Justice Lewison, so I've supplied that. The other matter that I mentioned before lunch was the menu of code rights. I was asked.
Is there anything in particular in this document you want to draw attention to?
I thought I made reference to it orally.
Yeah, paragraph 3.10.
Yeah.
Focus of these rights is on physical works.
Yes. Thank you, my lord. That was the Law Commission.
I think my lord was missing it. We had it.
Thank you. Thank you. Sorry.
We had it, but
so yes, the point of reference is 3.9, which identifies the old code rights.
yes.
And if one undertakes an analysis, but given the time I shall not, if one undertakes an analysis of those code rights and the new menu of code rights, there's a degree of correlation between those and some of the new code rights, and in particular the rights that were being relied on by the Deputy President. And the point I simply rely upon is that the focus of these rights is on physical works.
Yes.
Thank you, my lord. And then the second point was, I think in response to a question from my Lord Justice Arnold about the menu of code rights, and there is a recommendation from the Law Commission which I have handed up. This is after their consideration of the menu, the code rights, and then they recommend.
What is this document? Huh?
This is Law Commission, my lord.
Which point? Which document? Which Law Commission document?
The Law Commission report on the electronic communications code.
Final report.
Report 336, final report. Yeah. Thank you, my lord. Apologies. Should have clarified that. Yes.
Yes. Fine.
So yes, that is the Law Commission the report which we have looked at previously. This is a recommendation with respect to the code rights.
Yes.
And you will see the recommendation at 2.78. Again, if one were to undertake the analysis of 2.78 and compare that to the code rights which one now sees in the menu in the code, one finds that there's a conflation of a number of the code rights which now have been separated out, as it were, into the new code. And the one that is missing is the right to lock trees. That appears to have been added subsequently. There is no right to lock trees referred to there, but that is now to be found in the code menu. So those were, as it were, 2 points that were left over from lunch.
Thank you very much.
Thank you, my lord. And then in relation to the second issue about whether or not the right under paragraph 26 is parasitic, I shall take that quickly given the time that your lordship has indicated. The second issue is dealt with in my skeleton argument, which is at tab 2 of the core bundle. And if I may take it by reference to that, so you can go through that. So the second issue is commences at paragraph 58, page 26 of the core bundle, and then over the page I identified a number of headings under which that issue is then to be considered. I make reference to the explanatory notes, and they speak for themselves in a sense. I've highlighted the relevant passage of the explanatory notes dealing with paragraph 26, and it says provides that an operator may apply new right not provided for in the existing code, enables code rights to be granted on interim.
Where are you reading from now?
Page 27, my lord, under
27.
the heading explanatory notes. Paragraph 60.
Yes.
The explanatory note is set out,
Yes.
and it starts paragraph 26 provides
Yes.
that an operator may apply for interim code rights, new right not provided for in the existing code. It enables code rights to be granted on an interim basis pending agreement or the court determining a final agreement. Rights may be granted on an interim basis, and then A or B. when the court considers that there's a good arguable case that the interim code right will be made permanent at a final hearing. If the right is not made permanent at a final hearing, the interim right ends and the operator must remove the apparatus in accordance with Part 6. So, and then there's a reference at the bottom to explanatory notes as an aid.
Well, now, if you're right on your first point, none of this arises.
That's right, my lord.
So we're now on the hypothesis that you're wrong on your first
We're
point.
now on the hypothesis I'm wrong.
If you're wrong on your first point, explanatory note B doesn't apply because if all that's being sought is the MSV and nothing else, there's nothing else that's going to go to a final hearing.
Well, save that, as I mentioned, my lord, there is a reason for the MSV to be the subject of a paragraph 20 notice, i.e. to be parasitic, because, as I elaborate in this section, otherwise it deprives the site provider of the opportunity of arguing that the right ought never to have been granted.
So, do you envisage? I think you did. I think you did accept earlier on that if the MSV is in itself a code right, that there's nothing. Or are you? I thought you were saying you accepted that there was nothing to prevent it being the sole
That is right.
right being claimed under 20.
That is right.
But are you now saying that not only, and I thought you were saying in those circumstances if it's the only right, then the test under 121 would apply.
21.
21. Under 21 would apply.
That is right.
Yeah, 21
That is
would
right.
apply.
21 would apply.
Well, there wouldn't be a need to go to final hearing then, would there?
Well,
I'm just
there
trying.
would. If you have, as we postulated, you have the claim being made for whatever right it is by way of a paragraph 20 notice, and then the interim seeking that right in advance of the final hearing. And that, we say, would equally apply to an MSV, because otherwise, if it doesn't, what one has is that the code right has been imposed on the site provider by reference only to the lower threshold test of paragraph 26, depriving the site provider of the right to argue at trial that it ought not to have been
I've
granted.
absolutely got that point. I've absolutely got that point.
Right.
But I'm just trying to understand the mechanics. So, are you now saying that yes, if you can only apply from MSV, if you do want to apply only from this is on the hypothesis.
It's on the hypothesis, yes.
You can only apply for the MSV, but you must do it under 20. You must do it. Yes, you must do it under 20, under paragraph 20. And if you do that, I think you're now saying if you want to do, what you need to do is you need to, as you were, deploy 26.
Yes.
But you will then still have to have a final hearing at some later point.
That is right.
So that's the structural.
That is right. That is right.
As a matter of interest, where do you get that all? Where do you get that all from? I mean, where do you get the final hearing point from?
We get that from the terms of paragraph 26 itself. We get that from 26 in three respects. The first is that because the test is only a good arguable case, i.e. it is a lower threshold test without trial. So it's, in other words, it is interim in the full sense. One only has to show a good arguable case, which has been defined, and the Law Commission put this forward as the appropriate test, which the upper tribunal has accepted, as one side has a much better argument on the material available. One side has the much better argument. That's all that the operator has to show. And we know from decisions of the upper tribunal that this is a summary procedure in the sense that there's no written evidence, there's no cross-examination of oral witnesses. It's on are to be decided only on the documents put before the tribunal.
So you're not saying, if you go under 20, even if you only want the MSV, you have to, as a matter of form, put in for the whole thing at the end of the installation. You don't have to do that.
No, no.
But if you go for this, then yes, you can get it straight away, but you have to go under 26, and then there'll be a full hearing at some subsequent stage, working out whether you actually ever entitled.
Now, it may be that the operator, having obtained his interim right, decides he doesn't want to proceed with the full-blown hearing. He can then withdraw his paragraph 20, and the consequences of that will then follow.
But the operator will presumably already have gone in and done.
Well, exactly. That's what I'm saying.
What will the consequences of withdrawal be?
Well, the withdrawal, of course, will then be the subject matter of the paragraph 26, subparagraph 2b. If we looked at this earlier, the point being is that the court can make a determination, can make an order by reference to the occurrence of an event specified in the order. And now there is nothing stopping one from having a specified period, or say, until trial or further order. There's nothing wrong with that. And that, as a mechanic, as a piece of mechanics, would work.
But until further order won't help you because it's happened.
Well,
that won't help. So that would help you.
Well, until trial. Or, well, I mean, further order, what happens if, for instance, the... Yes, I suppose that's true. On the interim order itself, on the paragraph 20,
that's it.
You would have to have a withdrawal. Yeah.
But I'm sorry, I'm baffled. Maybe I'm being dense here. You're envisaging an application made firstly under paragraph 20 for an MSV only. Then, parasitic on that, we have an application under paragraph 26 for an interim order. The interim order is made, therefore the MSV happens, and after it happens, you say that the application under paragraph 20 can be withdrawn.
Well, because there's a substantive hearing still extant. Because
But there won't be if it's withdrawn.
I'm sorry, Marlon?
There will not be a substantive hearing
That is right.
if it's withdrawn.
That is right. There won't be a substantive hearing, but then the argument then is about costs. Because the whole point of having a substantive hearing, apologies for repeating myself, is that it's all about a balance in relation to the code. It's not a case of the code simply railroading private rights, as we've seen. It's a case of having to draw a balance.
Well, I understand the point about the code being a balance. I see the force of that. But I'm still trying to get my head around the mechanics that you're suggesting, because you've accepted that the operator can withdraw the application, in which case there is no question of balancing, because there never will be a substantive hearing.
In which case, then the issue becomes one of costs. The point about the substantive hearing is that, I mean, we're dealing with an MSV. This is why I say...
When you say the issue is one of costs, what do you mean?
Upon withdrawal. If there's a withdrawal, the issue will then become one of costs, because...
So the operator's got what it wanted, it's got its MSV, so what costs are we talking about?
But the cost of the interim order hearing, if there is one.
So what are going to be the parameters of that argument on costs, given that the MSV's got what it wanted?
Because the argument will be is that it would not have been substantiated at trial. Because all that's happened is that it's as if one had an interim injunction and the trial never happens. The interim injunction never has a trial because what happens is that the claimant doesn't proceed.
These kind of procedural analogies are problematic. I mean, if you're going to pursue that kind of analogy, what you're faced with is a scenario where the application for the interim injunction is determinative of the action. That's the true analogy.
Well, if it's determinative of the action, as I understand it, that may be on application by the parties, in which case you would probably have a paragraph 21 test, full-blown test determined. You wouldn't have...
It's in WL and Woods. So you don't apply American cyanide. That's where it leads to.
In which case they're not dealing with a substantive issue. The point I'm trying to make is simply that one can be misled into thinking that this is a procedural route to obtain rights which are advantageous to the operator. That is true in the sense that an MSV which is non-invasive, looks fairly innocuous. But this is, if upheld, if this procedural route is upheld, it will apply to every single code right, no matter how many rights are asked for. And what we say is that it couldn't have been intended that there would be a threshold test which was simply one which is a much lower test than the standard of proof at trial, because you don't have a balance of probabilities, it's just a good arguable case.
All right. I think we need to
Right.
understand the
So-
mechanism. So now we've got that now.
Yeah.
But I
Now,
think
where do
I
I
think
get that from as well? Your Lordship asked, where do I get that from?
well, but just before you do that, so I think where we've got to, again, this follows from my Lord's questions to you, is that once the MSV's taken place, we're not concerned with compensation there, because you've already answered the point that you can get compensation for damage done and so on and so forth. But what you're looking about now is the costs of applying for and being granted under 26 an interim order which you shouldn't have been granted. That's what you're looking at. And therefore you say, right, you shouldn't have been given it because you wouldn't have satisfied the 21 test.
Yes.
And therefore you should have to pay our costs.
Yes.
Now, in order to achieve that, you've got to have, in fact, a full hearing with oral evidence.
Well, why shouldn't the... I asked
I'm not saying that's
why
wrong.
shouldn't- Yes, why shouldn't the site provider be protected like that?
I'm not saying
Because-
that's wrong, I just want to get the mechanism
No,
right.
that is the mechanism.
So the answer is that on the issue of costs, maybe right, maybe wrong, I'm just trying to get the procedure right, there would have to be, or rather, let's put it a different way, in the way you would put it, the site owner is entitled to have that issue determined.
If he were to assert that it
Yes.
should never have been granted,
He's
or
entitled
not
to
have
have
been
that.
granted,
On the question of
if
cost,
there
he's
had been a
entitled to have that.
substantive hearing.
All right. I just want to understand the
No,
mechanism.
thank you, my lord. And now, your lordship asked me, where does one get that from?
Yes.
And again, we would respectfully seek to place reliance upon the Law Commission report, the full report, which is in tab 26,
Of which one?
the second authorities bundle, my lord. And there is a very lengthy extract starting at page or paragraph 9.48, bottom page reference 189,
Yes.
headed Enabling Early Access. And the whole of this section has been photocopied and is contained within this bundle. And there's a sort of fairly lengthy discussion about it all. And then we find, as it were, as a conclusion, paragraph 9.61, my lord.
Yes.
Does your lordship have that? It says, we've concluded that the revised code should allow early access, but only on interim basis. We recommend that this should be achieved by enabling code operators when making an application for code rights to apply to the Lands Tribunal for an interim order for access pending the resolution of disputes over payment. Such orders would only be granted on terms that give the landowner the right to vacant possession if a final order in favour of the code operator is not made before the expiry of the interim order. In cases where the operator and landowner are content with early access, the grant of interim access would proceed by way of a consent order. In other cases, there would have to be a contested interim hearing. We suggest that the code operator would have to satisfy the Lands Chamber that there is a good arguable case, and then there's reference there to Canada Trust, and that is what we see reflected in paragraph 26. That the test for...
The Canada Trust, though, is that the Canada Trust test is applied to questions which will not be decided at the full trial. It's all about gateways for service.
That was gateway for
So
service.
you decide the standard of good arguable case, or actually slightly modified now in light of Brownlee, whether you're satisfied with the gateway exists, and that's the end of that. It never crops up again in trial.
The note makes reference to Canada Trust and makes reference to it in standard, well-established cases where the applicant is seeking an order that will have significant consequences, such as an application for permission to serve proceedings outside the jurisdiction, and an application for a freezing injunction. in which case there would be a substantive hearing. And the context in 9.63 is that the test is being utilised in the context of a substantive hearing occurring later. Because coming back to the passage, if successful, the code operator will be granted interim access to the land. This is 9.63. On terms specified, the interim order include terms as to interim payment by consent, pending final determination of the consideration. And the tribunal might order interim compensation. But the objective of the interim order would be to enable access pending determination of valuation issues, and so the final hearing would resolve the question of consideration. In 964, whether or not an interim hearing is contested, it's important to ensure that the rights granted to the code operator do not place the landowner in an irremediable disadvantage. By giving to the code operator the full protection, this can be achieved by requiring that interim orders must include provision to the effect that, if a final order in favour of the code operator is not made before expiry of the interim order, the interim rights will come to an end. Landowner will be immediately entitled to enforce removal. Application will be listed for hearing and will proceed unless the parties have reached agreement. Thus, if consideration is not determined, or if the code operator obtains an interim order but is unsuccessful at the full hearing of its application, the landowner is able to remove the apparatus. And then there's a sort of general discussion. Given the time, I do not propose to read through all of that. I would invite your lordships to read through that, because the first part of it is dealing with why early access was needed, and in particular...
Just tell me which additional paragraphs do you
well,
want to read?
I would invite you to read the whole of 9.48
Right.
to 9.67, my lord. Because it explains why there was early access, because the reason for that is that there were many cases which were being delayed because of a failure to agree a price. That was the reason, and that picks up, as I say, and your lordship asked me where do I get that. We had the reference to the lower threshold. There was also the reference in paragraph 26.6, if you recall, to it being only a power to determine consideration, not a mandatory must. That, we say, is indicative of it not of there being a final determination.
Can I just ask you, if you look at 967, last sentence,
Of the Law Commission, my lord.
Yes.
Yes.
it talks about a final hearing. Landowner will have an immediate right to enforce removal of electoral apparatus. So I skipped the parenthesis, which is what I wanted to ask you about. At a final hearing, or the code operator discontinues the proceedings. So they made a recommendation about what was to happen if the code operator discontinued, but that's not reflected in paragraph 26 as enacted, is it?
Sorry, my lord, you're looking at 9.67.
Yeah.
In the words in parenthesis, or the code operator discontinues the proceedings. Yes. Well, that is reflected because we see that in subparagraph 7. Because the whole point of subparagraph 7, subparagraph B, is that one of the period specified in subparagraph A or the event specified in subparagraph B has occurred without, in either case, an agreement relating to the code right having been imposed under paragraph 20. So if he's withdrawn it, there will be no determination under paragraph 20, in which case you go straight to part 6 if he's installed ECA. That works. If in the normal type of case where you're asking for ECA to be installed, it may be that there will be a hearing, but if there isn't a hearing, he's happy with his interim period, whatever that is, he walks away. The balancing exercise that's undertaken by the code is that the site provider can then go straight to part 6, and we haven't looked at that, but part 6 enables the site provider to obtain removal of the ECA without having to terminate any code agreement. Ordinarily, when a code agreement is imposed, there's a two-stage process. You have to terminate it. Once you've terminated, you then can, and only then, can you remove the ECA. In order to terminate it, you have to serve an 18-month notice. That's the general position. You avoid that. That's the balancing exercise. So, my lords, moving on quickly, if I may. So we've looked at the Law Commission report. Going back to my skeleton,
Yes.
paragraph 66, 67, we've looked at that. We looked also, just before we move on, to the DCMS, if you recall, the executive summary, subparagraph 15, that had that first sentence about early access where there's a dispute over valuation.
Which paragraph are you on to in your skeleton?
We're moving on to paragraph 68, the terms of paragraph 66. I think I've dealt with that. I don't need to say any more about that, my lord. So we could skip through that. Then paragraph 27, paragraph 27 of the code, paragraph 71 of the skeleton. What I say about that is that, as said in the skeleton, it's a different animal. In the spectrum of the life of the code, if one can put it like that, paragraph 27 is looking at the end. What can I do to remove the apparatus? And what paragraph 27 is seeking to do is to protect the operator's ECA on the land, to protect the network. So what's happened in paragraph 27, when one looks at it, is that the code agreement has come to an end. It's been terminated. So the site provider has gone through all the mechanisms. He then has a right of removal. So it's a sort of last chance saloon for the operator. And then he can seek paragraph 27 rights. Paragraph 26 is essentially looking at the other end of the spectrum, where you want early access, where you want rights conferred. So they're looking at completely different things in our respectful submission. And that is the justification for the difference in approach. Because one is all about imposition, essentially, paragraph 26. That's why you have the good arguable test. And the other is looking about protecting removal, protecting the operator from removal, right at the other end of the life of the code agreement. So one's looking at the beginning, one's looking at the end. They're different. They're looking at different animals in our respectful submission. The next point I wish to make, so that's 27. Then we have sidestepping the paragraph 21 test, which is paragraph 76.
You've made quite a lot of these points already, haven't you?
I'm sorry, I've made a lot of those points already, my lord. Yes, I have, and I think that is right. Yes, the only point I haven't made is at paragraph 82. It's just worth mentioning that. Essentially, further code rights. So, on the respondent's case, you have your paragraph 26, and the hypothesis is, of course, it's an independent substantive provision in its own right. So you've got this paragraph 26 right. You've only had to establish the case on a good arguable case basis, much lower threshold. Your agreement comes to an end. There's nothing stopping you seeking further rights, arguably by way of a further claim, subject to the
Successive applications.
successive applications. In fact, the respondent, I know, doesn't dispute that. The respondent in its skeleton doesn't deny that it's possible for an operator to seek to manipulate the system. And what they say is that it's a matter which is dependent upon the exercise by the upper tribunal of its discretion.
Yes, because it's 26.3, the court may make an order.
Yes. So there is the potential. I put it like that because of the fact that it is a potential. One would have to look at the circumstances in which the claim is being made, but there is a potential there, and the respondent doesn't deny that. So you have this prospect of an operator obtaining the benefit of the code right without having to have a trial, obtaining the right by reference to the much lower threshold, and doing the same again, possibly. They don't deny that. Then on this Another matter I haven't touched upon is the 6-month rule, paragraph 87. So on the 6-month rule, it is a requirement of Regulation 3, referred to there, of the Electronic Communications and Wireless Telegraphy Regs 2011, that for the imposition of code rights, you have to deal with that in a 6-month period.
That's a paragraph 20 application, is it?
That is also, yes, that is a paragraph 20 application, that is right, Michael. So what I've said in paragraph 88 is that you can have this scenario, because paragraph 20 is a paragraph that is utilised only by the operator. Only the operator can serve the paragraph 20 notice. And only he dictates whether he's going to make the reference, because he has to wait 28 days, essentially, and then off he goes, if that's what he wants. So we have a scenario of you have, let's say, and I've given an example of 16-month interim period. You have no paragraph 20, because on their case you don't need paragraph 20. Then you come along and say, oh, by the way, I'd like paragraph 20. And one of the reasons why we say it's dependent on it's parasitic is to avoid that manipulation. That is one of the... And
it's parasitic on...
paragraph 20.
Parasitic on a paragraph 20.
Yes, being...
There being a paragraph 20
yes,
application.
that is so. Otherwise, you have this potential manipulation.
Can you just tell me, Mr. Clark,
Yes.
The regulation which I'm just looking at talks about the competent authority. What is it that makes the upper tribunal a competent authority? Is that the jurisdiction regulation?
I'm not able to answer that question immediately. Certainly, the tribunal has indicated that it is subject to that regulation. I think it's contained in a passage to that effect. Would you just give me a moment, please, my lord?
Well, you can come back to it.
Thank you. Yes, if I'll come back to that. But it's in the Islington case where this is touched upon. And I think I've made reference to it in paragraph 87.
But I don't want to hold you up.
No, thank you. I'm conscious, yes. So I would like, just if I may, just one final point. Yes, in relation to temporary arrangements over the page, paragraph 91 onwards. One of the points that's being made against the appellant is, well, what do you do about short-term arrangements such as music festivals, or which are, let's say, 7 days, or the other example is the lopping of a tree. On the music festival, again, we come back to what we've said before. There's no reason why it shouldn't be parasitic, because it is true that he only wants it for 7 days. But the site provider may say, well, I'm sorry, you've established it on a good arguable case basis, but I don't believe that you ought to be provided with that right, and I want that heard.
I mean, the odd curious feature is that you would have thought the logical position taken by the legislature would be, if on your analysis, that if you've applied for this interim right, which you were never entitled to, not that you should simply get the costs, but that you should be paid compensation. Because effectively what's happened is there's been an authorisation to go onto your land, or whatever they want to do, and they were never entitled to it.
Yes.
But there's no provision for such compensation.
Well, I thought about that. The way it seems to work is that the compensation is for exercise of the code right. And whilst the interim right, like with any order, I suppose, whilst the interim right is extant, it's in pursuance of the code right.
So you're
So
saying
your
the compensation...
you will still get compensation, but it's compensation whilst the right was being exercised. And it may be that on the assessment of that compensation, you would then have regard to the fact that the right, as it were, ought not to have been granted. But paragraph 25, which we did look at...
I thought that was quite important for you in your analysis.
Well,
I mean, it seems a slightly weak point, I'd have thought, from your perspective, to say, well, we should have got to get the cost of the application shouldn't be made.
yes.
What you really want, I'd have thought a landowner wants, is to say you should never have been there, and I don't know how they
Yes.
assess the compensation, but the assessment of compensation would be
Well,
for having done something you were never
Yes,
entitled
I
to.
can see the argument. 25.1, which we did look at, says that you can be paid compensation for the result of the exercise of the code right. Yes, so that is obviously the exercise of the right itself,
Not for it having been wrongly granted.
not for it having been wrongly granted. And one can see the argument. I mean, this is a matter for, I suppose, subsequent debate, if there is one. But either it is said that the order of the court conferring the interim right, whilst that was extant, it was lawful. The exercise, it was done in exercise of the code right. Alternatively, it is said that it wasn't. Now, there is in my mind a case relating to landlord and tenant of relying on an order. The order is then revoked, and it's not a trespass because you were relying on the order. I think the landlord. Expert Clearing Hillgate House. Thank you, my lord. Yes. Yes. So it may be that the operator says, "Well, hang on a minute. Yeah, I know it's the case that it ought not to have been granted, but your compensation won't."
Well, you may not need that. I mean, you might have a claim, I suppose, at common law. I don't know.
You may have a point. Common law.
But it doesn't look as though that's the point. I mean, the point only arises because of the way you put your case. It's parasitic. I mean, if it's not parasitic, the point's determined according to good arguable case, and that's it.
And that's it.
If you don't think that the court should have said it was a good arguable case, you can appeal. If you need to appeal, if there's a point you can appeal on. Otherwise, you're fixed with that. The point arises because you say there needs to be an opportunity at some point for the site owner, even in relation to an MSV, to say, yes, but you wouldn't have satisfied the 21 test, and if you can't satisfy the 21 test, then you should get compensation. The trouble there is, I fear, is that actually it was properly granted under 26 as an interim right, because that sets what the standard is, and that's good arguable case. The fact that at trial, so for example, if you get an interim injunction, you don't get, and at the trial it's held that you don't get the final relief, a final injunction, you don't get compensation. I mean, there's a cross undertaking in damage.
There's a cross undertaking in damage.
You don't get compensation from the court, as it were, for having wrongly granted the right.
What you obtain is
cross-undertaking
cross undertaking,
Yes.
because the cross undertaking is if it's found at trial.
I think what you're saying is, I think that you're kind of driven to, I think what you're saying is, well, actually, the tribunal itself can award compensation under 25, which is quite a dramatic thing to say.
Well,
for having wrongly granted the interim order. That's quite a big
I don't think I went as far as that. What I suggested is that the compensation under 25(1) is obviously in exercise of the code right. Now, to what extent, therefore, it is then decided that one takes into account the fact that the code right, because it's being considered subsequently, or never to have been granted, is an interesting question to which I don't immediately have the answer.
Well, it's very likely undertaking in cross-undertaking in
Lack of
damages.
cross-undertaking in
Looking
damages.
at practice direction 25, which requires an undertaking by
Yes.
the applicant to the court to pay any damages which the respondent sustains, which the court considers the applicant should pay.
And
Here we've got pay compensation for loss or damage that has been sustained as a result of the exercise of the right.
Yes, my lord.
I don't think it's
one
loss
can see
or
the
damage.
correlation.
It's really the fact that they may not have done any damage. They may not have caused any loss.
I suppose
What you're
that-
really saying is that the order shouldn't. That's why you're
well,
saying
the damage
quite
is the damage, of course, is entering the land without authority. I suppose that's one. And, well, that's the debate, isn't it? I mean, I'm.
All right, we're just trying to see what
Yes,
the ramifications
yes,
will
the
be.
ramifications would be that there is, we say, an entitlement to compensation. To what extent that would entitle one to argue that there is a correlation with the undertaking. One can see, as Lord Justice Lewison mentioned, that indication. I suppose the... Sorry, my lord.
I'm sorry, I interrupted
No,
you.
the only other thing, of course, is that perhaps as part of the interim order, such an undertaking is asked for, if it's to be found at trial. And 26 has a number of matters, one of which is it picks up 23, which is to give effect to the code right. Well, I mean, and such terms as the court thinks appropriate.
But can we come back
Yes,
to the
my lord.
point you were on, which I think is quite an important point, is music festivals and other temporary arrangements. So we've got something that's taking place for, let's say, 7 days.
Yes.
So access is only desired ever for a 7-day period.
But
So how do we deal with that?
well, because the assumption you're making is, of course, that the operator is suddenly thinking, oh, that's good, I want the festival. These sorts of things are planned well in advance. He doesn't knock on the door on the Friday afternoon on a 7-day festival commencing on the Saturday. He has to install his ECA, he has to prepare. So he's preparing well in advance. Now, it may be that he's only seeking 7 days, and at the end of the 7 days, the interim order will come to an end. On my case, it's parasitic. There will still be an entitlement for the site provider to argue it ought not to have been granted. There is nothing unworkable within the code about that, because at the end of the 7 days, he's enjoyed his 7-day period. There are a number of ways in which the code can deal with that. The first is that the operator withdraws his paragraph 20. We've dealt with that. The second is that, in fact, having had the 7-day music festival, the right has become spent. And if you'll recall from this morning, one of the essential conditions of exercising a code right is that it's for the statutory purposes. If you're not exercising the code right for the statutory purposes, that's it, you're not within the code. And so again, you have no code protection. That's another mechanism.
Have you got an absolute right to withdraw, or is it subject to the tribunal's consent?
Excuse me, I might not. I apologise, my lord, I'm embarrassed to say I haven't checked that. Whether there is a rule similar to CPR 38, I will try and look whilst Mr. Siegler's on his feet, but we have some of the rules here. Thank you, my lord. Yes, apologies, I've run over time. I just did want to make one point about the tree lopping, because it really picks up also a point about essentially short-term rights. I mean, the argument is that it's only a one-off thing. I think one needs to take a step back and think about the tree lopping, because our submission is it's a very unusual animal to have a tree lopping right on its own, one-off. Because if one thinks about it, if the operator, because of course, let's start again, the operator is wanting this tree lopping right because he's concerned about the interference with his ECA. So we're making an assumption that, of course, the ECA must be there somewhere on land. If the ECA is on the land of which the operator has exclusive possession or exclusive occupation, he has a lease or contractual license, there may be something in the agreement dealing with that. He may have a right to cut it back. It may be a common law right, nuisance, a trespass. So there's something that he can rely on. Alternatively, let us assume that he doesn't have the possession or occupation. Then he may seek a tree lopping right. I was trying to think of an example. Let us assume you have a line under farmland. A line is apparatus, so he has his ECA, the operator has an agreement, it's under the farmland, he's worried about the encroachment of some roots. So he doesn't have exclusive possession or occupation of the farmland, he's just got his line under it. So what does he do? He asks for his, let's assume, is covered by the tree lopping or vegetation lopping right. So he asks for that. Now, it's true, that may be a one-off, but we say, this is an example of the tail wagging the dog. Because there may be postulated a most unusual circumstance of someone wanting a tree lopping right, that somehow or other that requires the code to be interpreted so that paragraph 20 is not parasitic. Of course, the other thing one must assume about the example I've given is that the code agreement relating to the farmland, the line under the farmland, says nothing about what the farmer has to do in relation to controlling vegetation. And normally, an agreement between an operator and a site provider will make provision about repair, obligations in relation to maintenance, etc. So with the example that's being put against me is a very, very theoretical one. It's one where the code agreement says nothing about the obligations of either party and you want a code right to lop a tree.
But wouldn't the sort of situation envisaged be one in which the operator is the owner of a piece of land on which it erects a mast for purposes of its network, and its neighbour, who has no contractual relationship, has a tree on the land which is interfering with the mast somehow or another. In that case, all the operator wants is the right to lop the tree, or to get the neighbour to lop the tree, which is an alternative.
I accept that, but that would be an occasion in which one would want the right to lop, and the land, the site provider, the occupier for the time being, would be the occupier of the adjoining land. That would be a one-off, I accept that, but I come back to the point that that one example.
Yeah. Your point is that because you can think of an example, it shouldn't.
It ought not to be. I mean, as I've said right at the beginning, and I apologise, I've run over time, but as I said at the beginning, the general run-of-the-mill sort of case that one is dealing with here is not a right to tree lop, one-off. It's an extreme example, and obviously absurdity isn't a rhetorical device that is employed often. But that ought not to dictate the way that your lordships interpret the code. My lord, just finally, access is also put as another example. They say there's only a right to have access once, often. Well, one of the points I would invite you to have regard to on that, of course, is that there is a statutory provision, paragraph 17 of the code, which is not in the bundle, apologies, which confers on the operator essentially an absolute right to share or upgrade the ECA. There are a couple of qualifications, but essentially it's an unconditional right. Well, if you needed a crane to install your apparatus at the beginning, you'll need a crane to install it later, particularly with the rollout of 5G that we're now having. My lords, I've run over time. I apologise for that. Those are my submissions.
Thank you very much.
Thank you so much.
Well, before I forget, just picking up my Lord Justice Lewison's question about the 6-month rule, references paragraph 97 of the code.
Of the code.
Yeah, of the code. That
Para 97.
Yeah, references regulation 3 of the Electronic Communications and Wireless Telecommunications. That's the 6-month.
Is it in the bundle?
Yeah, it is.
Oh, yes.
So, what I was going to do, subject to what your lordships tell me otherwise, was just to take 3 preliminary points about the code and then go straight into issue 1 and then straight into issue 2. The 3 preliminary points are these. First of all, the purpose of the code is to make it cheaper and easier for operators to roll out infrastructure and thereby enhance connectivity across the country. My Lord Justice Lewison looked at this in the case called Cornerstone against Compton Beecham. That's tab 13 of the authorities. We don't need to go to there, but the reality of it was that the operators were imposed obligations in terms of conditions in their licenses for coverage. So they were told you've got to cover the rural areas too properly. And at the same time, the Electronic Communications Code was reformed to help operators extend their networks and deploy infrastructure and make maintenance cheaper.
You get that all out of that authority, do you?
Yeah, it's paragraph 3 of my Lord Justice Lewison's judgment in Compton Beecham.
Thank you.
And the reason why the code was meant to assist operators simply reflects the recognition of the importance of their services. It's not just an economic importance to do with business and promoting social inclusion, but also it saves lives. 2 out of 3 calls to the emergency services are made on mobile phones. In this particular case, one of the reasons why we needed the University of London site was because the St Mary's Hospital site was overloaded. So the purpose of the code reflects those objectives. That's the first point. The second preliminary point is that paragraph 20 on the one hand and paragraphs 26 and 27 on the other hand are very different. And 3 of the key differences are as follows. First of all, as we've seen, the tests are different. The test under paragraph 20 is public benefit. The test under 26 is good arguable case for public benefit. And the test under 27 is about maintenance of the service provided by the operator's network pending determination of a paragraph 20 application. The second big difference is there's no statutory continuation of a paragraph 26 or 27 right, whereas you've got this 1954 Act-like statutory continuation in relation to paragraph 20 rights. That comes in paragraph 30 subsection 3. And the third big difference, I'm going too fast, that's because I'm rushed. 30 brackets 3 provides that subparagraph 2, which is the continuation of code agreements, doesn't apply to paragraph 26 or paragraph 27 rights. So the whole continuation regime doesn't apply to 26 and 27. That's the second big difference. And the third big difference is this. A paragraph 20 code agreement can be agreed without the tribunal's involvement. That follows from the fact that the right to apply to the tribunal only arises if the relevant person does not agree to the code agreement. And that's in paragraph 20, subsection 3A. So if there is a consensual agreement and it's paragraph 20, nobody needs to go to the tribunal. In contrast,
It needs to go to the, they have to start in the tribunal.
but not if they've agreed it beforehand, they don't. If a notice is served under paragraph 20, brackets 2, and it's agreed, nobody needs to trouble the tribunal. But, and my Lord Justice Lewison picked this up earlier this morning, under paragraphs 26 and 27, you do need to go to the tribunal. In fact, under paragraph 26, the presence of agreement is one of the circumstances in which an interim right will be imposed. And that's paragraph 26 subsection 3A.
What's the point of that?
The point of that is this. They couldn't have allowed people to have paragraph 26 outside the code, because if you do it privately, as my Lord the Master of the Rolls supposed might be possible, you will fall foul of paragraph 100, which says that you can't contract out of part 5. And part 5 is the statutory continuation, the 18-month notice, and all that protection. The only way out of part 5, security of tenure, 18 months, is to have a paragraph 26 imprimatur. Because paragraphs 26, subsection 7 and 8 disapply part 5, as does paragraph 30, subsection 3, which we've just looked at.
I'm not sure I've kept up with this.
Right, I'm sorry. This is because some of us have been looking at this code for months.
But I'm sorry.
You're not allowed to contract out
Part 5.
of part 5.
That's the continuation provision.
Yes. And if you had a private paragraph 26 agreement, you would be contracting out of the 18-month notice and the statutory continuation, because it would be a code agreement that part 5 did not apply to. That's why. The whole thing wouldn't hang together otherwise. It's to accommodate. It's to accommodate the restriction on contracting out.
So I just want to make sure I understand one point. It seems quite important in your submission, but maybe I misunderstood this. Is one of the points you've made of these three, maybe your second point? I'm not sure. Is it that because you can have an agreement which is out, so you can have an agreement under which you don't go to the court at all?
Under paragraph 20, yes.
Paragraph 20, you can just agree it and
Yeah.
you get no into the court.
Just agree.
But the point you're making is, even in such a case, if you want you may disagree about interim leave, for example. Is that right?
No. Even if
And
you
you'd go under 26.
my Lord, if your Lordship looks at 26.3a,
Yes.
you see that even if the operator and the relevant person have agreed to the making of the order,
Yes.
you still appear to need the imprimatur.
I think I'm moving toward. I'm trying to grasp towards that. So your point here is that 26 combined with 20 envisage the very situation where you do go under 26, even though you haven't got and you don't need to get a 20.
Well,
Is that the kind
I'm
of
going to come on and develop that later in the context of issue 2. All I'm trying to do...
Yes, I'm looking at issue. I think about issue 2. But is that correct?
Yes, but all I'm trying to do at the moment is lay the ground to show the court how 20 on the one hand and 26 and 27 on the other hand are very different creatures. And one of the big differences is you can't actually privately outside of the tribunal do a 26. It won't have you're not allowed to do that because it falls foul of paragraph 100, which says you can't contract out of part 5, which is what that would be. And the third preliminary point I just wanted to make is that the thrust of this code.
What was your third?
No, I think that was the second. The second one was the difference. The first one was how this
difference under the second point.
Yeah, there were 3 differences.
I see.
And that was the third difference under the second point. This is now the third preliminary point.
Oh, I see.
Which is that whenever the tribunal imposes rights, it can do so with such modifications as it thinks appropriate. That's in 23 subsection 1, and it's imported expressly into both paragraph 26 and 27. It's imported expressly into 26 by 26(4)(c), and it's imported expressly into 27 by 27(4)(c). So, that means that when the upper tribunal imposes an interim right under paragraph 26, or a temporary right under 27, it can and will specify conditions, such as the date it will end. Or it could specify that a paragraph 20 application must be served within a certain time, or on a particular event arising or finishing. Perhaps it will specify that a paragraph 20 application must be made on the obtaining of a planning permission. So the ability of the tribunal to impose conditions on interim rights is pretty important. I'm now going to go straight...
If the tribunal were to include a provision in an agreement imposed on the parties that a paragraph 20 application should be made by a specified date, let us suppose, or if planning permission is granted, that takes effect as a contract between the operator and the relevant person.
Yes, it does.
How would you enforce?
Well, it would say that what I have in mind is that the condition would be that the paragraph 26 right lasts until the earlier of such and such a date, or when a paragraph 20 application is made.
Right. Well, I want to carry out an MSV. I want to do it in November.
Yep.
I go to the tribunal, and the summary decides yes, you can have this right in November, access permissions and so forth. And we direct that you have to make a paragraph 20 application.
That if you haven't done it by the end of the calendar year, you're going to have to make a full paragraph 20 application.
Well, I don't mind that because
Yep.
I've done the MSV by then.
But it answers
So
a lot.
what practical value is that?
It answers a lot of my learned friends' questions about this could go on and on and on. Because there's a jurisdiction when it comes to because there's a discretion when it comes to conditions. The tribunal has the ability to meet a lot of my learned friends' concerns under his issue 2. That's what I was laying the ground for on that. So, my Lord, if I can go straight into issue 1. Issue 1, which is the question of has the tribunal got a jurisdiction to impose an agreement for an MSV, or in short, the question is an MSV a code right under A or D? A couple of general points before I look at A. First of all, it was found as a fact here by the Deputy President, and we can't go behind that finding of fact because this is an appeal from a tribunal which can only be on a point of law, that an MSV was a necessary step to be taken. And the reference to that is paragraph 74 of the judgment. 74. The Deputy President found that an MSV was a necessary part of installing electronic communications apparatus.
He also finds it 77 and
Yes.
80 something.
Indeed. That's they'll go slightly further about how my learned friend's arguments would drive a coach and horses through the
77 and 88.
yeah. Now, my lord, that finding of fact makes my learned friend's argument on this issue 1 quite odd, because nobody seriously disputes that an operator can carry out an MSV as part of a paragraph 20 claim. But if a survey is a code right for the purposes of paragraph 20, it must be a code right for the purposes of 26 as well, because it's the same menu.
No, I don't think you're right about that. I don't think Mr. Clark does accept that an MSV is a code right for either paragraph. I think that's his first point.
Well, there's a finding of fact that it was a necessary step to be taken.
Well, I follow, but he says even so, it's not expressly mentioned. This is expropriatory, and one must adopt a strict construction, etc., etc. So, I mean, I don't take it for granted that he accepts it as a code right, because my understanding is that he doesn't.
All right, I will. Second general point is this. It wouldn't have been easy for Parliament to have legislated in paragraph 3, specifying every part of the installation separately. It couldn't have said, well, the operator's got the right to go through the common parts, it's got the right to open fire doors, it's got the right to use ultrasound in my Lord Justice Arnold's example, it's got the right to use drones to photograph from above, it's got the right to drill holes and hammer nails. It wouldn't have been practical for Parliament to have set out every single aspect of what an installation might involve. So, we say, Parliament in paragraph 3 has used wide terms deliberately. And we say, therefore, in terms of A, that the right to install electronic communications apparatus in or over land includes a right of entry, obviously, because you can't install without entering, and it also includes a right to carry out a survey, because on the finding of fact, a survey is a necessary step to be taken.
Well, but that might presuppose what Mr. Clark does not accept, that there's any right actually under the code at all to go on buildings. Because his point is that the only right of entry is that now contained in Schedule 4, and that does not allow entry onto buildings.
Lord, I'll come back to that if I may. I will deal with that separately, because we say it's a very different right to that that's been portrayed for reasons I'll explain. But all I'm saying at the moment is that it makes sense for Parliament to use wide terms and for all necessary rights to be encompassed within it. My Lord, I need to start with A and then move on to D quickly. A, if I could analyse that first in terms of the meaning of the word install, and secondly in terms of practical implications of my learned friend's submissions. What does install mean? Well, it obviously can have different meanings. You can have a narrow meaning of the word install. That's just a person in a high-vis jacket with hammer and nails coming along and fixing the ECA to the roof mechanically without a thought process, no examination of lines of sight, no looking at obstructions, no checking power supplies, no thinking. That's the minimal meaning of the word install, hammer and nails, just physically putting something there and that's it. The wider meaning of the word install is that it includes the right to survey and apply a thought process to the installation process, where and how the ECA should be fitted, what health and safety issues, if any, arise. And what we say is, putting it colloquially, this is a specialist statute which revolves around technology which can't just be plonked down, and nobody could be plonked down. What matters in terms of capacity and coverage, which are the big things that the government wanted, is such things as power sources, making sure the antennae point the right way, making sure that the roof is reinforced in the right places so it can take the weight of this equipment in all weather conditions so that it doesn't fall and then the signal's interrupted.
All that makes perfect sense once you've decided you're going to install it. But what if the result of the MSV is you decide You're not. Then how can that be part of a right to install?
My lord, if your lordship was to allow a company to come round to install broadband in his house, they will want to come and find out where the cavity walls are and where the underground cable can be accessed, and that is part of the installation, whether or not they find the house to be suitable for that installation. If they find it's not, then what they did in checking the cavity walls and looking for the cables was still part of an aborted installation process. What we say is that the MSV is part of the installation process in the same way that an X-ray being taken by a dentist is part and parcel of installing a crown or a bridge in one's teeth. It yields essential information for the physical part of the installation, but it's still part of the installation, even if that turns out to be abortive, because it's found that the patient, as a result of the X-rays, can't take the exercise, the pain. And this issue arises in relation to works as well. The question of works under D, I'm not going to go on to works now, except to say that we accept that if an installation is never going to be done, and there's no intention to carry it out, then an MSV will not be for or in connection with an installation. But if the whole point of doing it is because there is an intention to do the installation, subject to the results of the MSV, it is in connection with.
Sorry, let me just follow that one through for a moment. I'm an operator, I lose a site near Paddington Station, want to replace it. I've got 5 potential sites in mind. I only want one of them, don't know which one. I'm going to carry out 5 MSVs on 5 sites and pick one.
My lord, that's not
Can you say of any particular site that?
No, my lord, because we wouldn't need 5 installations.
No, I'm saying that we're only going to use one.
But we
We're
wouldn't
gonna
be
look at 5.
doing 5 MSVs. The way it works is that we say we have an intention to install apparatus on that site because that's the perfect site, and we will install that installation subject to the results of the MSV.
Right. So that single site then has been identified.
The evidence in this case is that this was the site this is far and away, we say, the best site. This is the only site that will do the trick. It's fantastic. It's so high up, it's got 360-degree range.
How would it work if there were more than one contender?
We do one at a time.
Where?
Because we don't need to.
Well, I follow, but how would you be able to say of any one of the contenders that's the one until you've done your MSV?
Well, because from ground level, it's obvious which is the best one. Height is an enormous thing. So from ground level, it's obvious. We can tell immediately that's our favoured site, and so we will apply under paragraph 26, have a look round, see if it's suitable. Well, subject to it being suitable, we'll install it.
Can you just point me to the finding of the judge where he says that?
Where he says...
Where he says that this is the place where they will install, because it's better than any other site.
My Lord, I'm not taking it from a specific paragraph. It's because I've read the evidence and the cross-examination.
I know that, but I mean, we have to act on findings of fact, and you're relying upon this as part of this submission in 3A.
Well, I'm answering my Lord Justice Lewison's hypothetical rather than evidence-based query about if the 5 sites...
Paragraph 2, the Cornerstone believes that the building is likely to be the most suitable venue.
Yeah. Thank you. So, what we say about A and install is that the statutory context, which is technology, requires the right to install electronic communications apparatus on, under or over the land as including necessary preliminaries, because these things require reconnaissance and preparatory work. And we say this court is entitled to think about practical implications. Merely installing apparatus without preparatory steps would be absurd. You wouldn't know before you got up there whether there's sufficient space for the apparatus or to do works around it, or whether a helicopter is needed. There was one site in central St Giles where they got up there and there was loads of cabinets in the middle of the rooftop which were full of window cleaning pulley machines and air conditioning equipment. Therefore the design had to be radically changed so that the apparatus went only around the perimeter of the site and all the aerials pointed outwards off the edge. So it's obvious that that installation will require a reconnaissance. And my Lord, we ask you, Lordships, to approach this in two stages. The first question is there any way that an installation can be effected without a practical entry on the land? No, obviously, you have to be on site to do something to the site. Question two, therefore, is there any basis that the word install should be read so as to mean that the University of London only have to allow the physical works of installation and can bar any sort of necessary reconnaissance? We say no, for the contextual reasons we've mentioned, the context being this is technology. And my Lord, that's what I wanted to say about meaning. I need to move on to practical implications. The first is a concern about trespass. If my learned friend is right, and what the meaning of the words install is only to do physical works, then what happens if when the workers get up there they immediately see difficulties with a weak roof or see that there's a protected species there? If they don't start their physical works immediately with their hammers and nails, they will be rendered trespassers at that moment and become liable for damages for trespass, because there's no code protection for them. Well, it's an absurd position. Once the worker starts thinking about it, and until and unless the worker starts making holes with hammers and nails, there's no code protection. And we say it's an incoherent outcome. The other practical implication which we're concerned about is this. If the erection of this equipment is not permitted development, which it won't be in many situations, the operator needs planning permission. And the operator can't therefore put any bolts into the roof or carry out any physical work until it gets planning permission. But you can't apply for planning permission without drawings. How do we get the drawings? And whether or not paragraph 26 is parasitic on paragraph 20, and whether or not this is done under paragraph 20 or paragraph 26, or both, if install only includes hammer and nail work and drilling the hole work, under what code rights do we ever get drawings for planning permission done? And the answer to all that is exactly what the code was meant to be avoiding, which was ransom. My learned friend's end point is that an operator can agree or have imposed upon it an agreement whereby £100 is paid for a code right to put apparatus on a roof. And then the owner of the land can ask for £1,000 to have the right to come on and survey. It undermines the code, as the Deputy President found. It creates a ransom position before the code even comes into operation. There's no question that the University of London is a venerable institution, but this is not a theoretical possibility. In this case itself, the University of London asked for between £30,000 and £60,000. That's the way it was put. We want between £30,000 and £60,000 in order for entry to the survey. So where this argument ends is ransom. Let there be no doubt about it. And that is not the purpose of the code. And one thing that the Law Commission did mention, it didn't go into too much detail about paragraph 26 or interim rights, but it did say on a number of occasions this is not to end in ransom. We are avoiding ransom situations. Well, if I can look at D, it's we argue A and D in the alternative, or say we can have both. The right under D is the right to carry out any works on the land for or in connection with the installation of apparatus. And we say that the words in connection with do add a lot, because it widens out what's involved significantly. If I have an intention to rob a bank tomorrow, if the coast is clear, then the work that I do this afternoon on the getaway vehicle, in terms of checking the tyres are okay and checking the oil, is still work in connection with a bank robbery, even if the intention is conditional on the coast being clear. And we say these works in connection with do a lot of work in our favour on these submissions, as does the word any. And indeed, the word any and the words for or in connection with are wide terms. And the question arises, why would Parliament have used wide words, such as any works or for or in connection with, if they'd wanted these rights to be interpreted strictly and narrowly, and to exclude something which the Specialist Tribunal has found as a fact is an essential element of the installation of apparatus. And it's striking that on D and A, my learned friend's analysis is completely bereft of a code-consistent rationale for the narrow reading of these words. It creates no benefit other than to artificially exclude from code rights a necessary step, creating a potential ransom in their favour, which is quite cynical. So we say that works, as the Deputy President pointed out, at paragraph 68 and 76 of his judgment, is an imprecise term, and it's general, and it can easily extend to the kind of work included in an MSV. It's right that the Law Commission said physical works is the focus. Yes, it is the focus, but that doesn't mean that's all there is to it. Surveying is work in connection with the installation. It's preparatory work. In fact, the expression surveying works is a perfectly understandable one used in professional life. You can carry out surveying works without having to have a hammer and nails. Design works is also a recognised phrase. You don't need a hammer and nails to be doing works. So that's meaning. The second point, implications of my learned friend's argument. Well, the logical extension of my learned friend's argument is that the less intrusive the MSV, the less likely it is to be a code right. And the more intrusive the MSV, if it involves ripping the roof up, the more likely it is to be a code right. If works just mean physical works, his submissions are goading us to find some way to do some physical work on an MSV, like lift up the roof surface. We could do that.
Well, I think you could be accepted that taking a core sample would be enough.
Yeah, we could say, right, we're going to change all MSVs as a matter of policy and practice. All the workers doing MSVs must now take the roof up, part of the roof up. We could do that, but it's a ridiculous objective, and it's not necessary, which Parliament can't have intended to drive us to. And it just seems absurd to us that a gung-ho operator should be able to obtain interim rights for installation or carrying out works on the site without properly inspecting it first to determine suitability, go up there, send the men up there, start with the hammer and nail, start banging, but then a diligent operator who wants first to take proper surveys and avoid needless violence to the site can't do so and is subject to the ransom. It's the practical implications of this, once one thinks about it, means that my learned friend's arguments cannot be right.
This is all on the assumption there's no right outside these provisions.
I'll come back.
Correct.
Yes, I will come back. I'm going to come to that in a moment. Before I do that, can I have a quick look at the Marks and Spencer case, which is in tab 3 of the black and orange file, the thinner black and orange file. We have had a quick look at it, but if I could do it This is a case where planning permission was granted in 1938 for the erection of a new building. And there was a condition on that planning permission that works must begin within 18 months. And the person with the benefit of the permission did demolition, but then war broke out. And so the question was, when the works commenced, and was demolition part of the erection of the new building? That was the question in the case. And as well as the part on page 572 that my Lord Justice Lewison referred to, I wonder if I might show your Lordship page 563. Just at the end of the middle paragraph in the judgment of Lord Justice Jenkins. He says, therefore it seems to me that the intention of the section makes it of relatively little importance whether the actual work in question is work of demolition or of construction or of anything else, provided it is clear on the facts that the work did genuinely form part of the operations necessary to carry out a building project. And my Lord, we say that can be the test. The test is whether the MSV is genuinely part of the operations necessary for or in connection with the works, using the word of 3D. Well, of course it is. Indeed, there's a finding of facts to that effect. It's all part and parcel of the same thing. And, as your Lordship will have seen from our skeleton, we rely on the Attorney General Great Eastern Railway case, which says that a statute carries with it all necessary ancillary powers that are required. I would have gone into that and shown you, Lordship, but the references are on our skeleton, and I'm not sure that I need to do that. Well, before I come on to just a couple of points, before I come on to the rights of entry. There's been discussion about 3F, and F is about entry. These code rights, there is a pattern or a rhythm to them actually. The way it works is that you have to look at them for a long time to see this, but the first three are about apparatus. A is about installing apparatus, that's day one, and then B is about keeping, so that's like days 2 and 3, and then C is about inspecting and working on, it's about longer term troubleshooting. And then that pattern repeats itself in D, E and F, but this time not in relation to apparatus, but in relation to land. So the second three are about the land, not the apparatus, but they repeat the same pattern. The first one's about day one, installing, carrying out works on the land for in connection with the installation of apparatus. Then E is about keeping, days 2 and 3, it's carrying out works on the land for and in connection with keeping it there. And then F is longer term troubleshooting, entering the land to inspect it. So F is a perfectly sensible part of the pattern that is shown in the first 6, and then the last 3 are sui generis really, but there's a pattern to the first 6. Now what we say is that F actually supports us because, I mean, there's no reference to entry in A either, whereas there is a reference to entry in F. And we say that's because entry is taken to have been necessarily encompassed in A, which is our point. F also is different from some of the others, not all, but because it refers to elsewhere. So it's about long-term troubleshooting in relation not just to the land, but also to elsewhere. It's also about altering and repairing where the apparatus ex hypothesi is already there. So it might not need site inspection. Some of the things that may need to be done on a long-term basis could be done remotely. The antenna can be adjusted remotely. So the express right to enter is necessary under F to clarify that there's also a physical right of entry. So our answer to the question posed by my learned friend, why isn't there a right to assess suitability under 3, is simply that it is there. It's there under A and it's there under D. because you can't do those steps sensibly without a survey. There's a principle in 23.5 which is also important, which my learned friend relied on. 23.5 is the principle that the terms of any agreement, and this of course is imported into 26 and 27, the terms of any agreement must include the terms the court thinks appropriate for ensuring that the least possible loss and damage is caused by the exercise of the code rights to the persons who occupy our own interests or are there from time to time. So there's a principle here, least possible damage. We say, yes, our course is consistent with the least possible damage because it's only by reading A and D to include a right to an MSV that we can be sure that the fewest possible rights are used under the code, because we will only be seeking full paragraph 20 rights if the site is suitable. It is to allow targeted installations. We say allowing an operator to survey the land to see if it's suitable for the installation of apparatus causes the least interference to the individual, compared with proceeding with a full-blown paragraph 20 application wherever the site might be suitable. My Lord, I need to look at other rights of entry. The first one mentioned by my learned friend was the rights of entry under the Senior Courts Act. That's a right, a procedural right to inspect in connection with a dispute. And it's in tab 14 in volume 2 of the Greek Black File. And what we say is that your Lordships only really need to look at it. It's section 33 of the Senior Courts Act to see that this is not what we're talking about here. Paragraph 33 says, on the application of any person in accordance with rules of court, the High Court shall, in such circumstances may be specified in the rules, have power to make an order providing for any one or more of the following: inspection, photographing, preservation, custody and detention of property which appears to the court to be property which may become the subject matter of subsequent proceedings in the High Court. Well, you just have to look at the list of words at the beginning: inspection, photographing, preservation, custody and detention. This is about fairness in a trial. This is about not destroying matters that may become relevant to a dispute. It's not about our situation where we're surveying to see whether a site is going to be useful for an installation, and there may not be a dispute. If we go up there and find protected birds, there's not going to be a dispute about that site. The second thing we say is the code must be assumed to be comprehensive in this respect. And we are at a loss to see why my learned friend would put this forward at all, because under the code, in return for the exercise of a right under paragraph 26 for an MSV, there is consideration, there's compensation if there's damage, there's it becomes deemed to be a code right. This is not in their interests. There's no compensation or consideration in relation to that procedural rule. So we say that can't cover it. The next is Schedule 6, Paragraph 4 of the 2003 Act, which I know my Lord the Master of the Rolls is interested in particularly. Well, can I just say this to start with? This is really quite odd. The first instance decision in our case concerning the University of London is the only case we can find that even mentions Schedule 4, Paragraph 6. There's no discussion of this in any other case. There's no discussion of it in the textbooks beyond a bare recitation of its terms. And there's no mention of this right under Paragraph 6 of Schedule 6, Paragraph 4 in Law Commission or in the government policy documents. And my lords were shown paragraph 70 of the judgment. And what the Deputy President said here in paragraph 70 was that he was referred by my learned friends to the consultation on the Law Commission's proposal, in which one consultee, Cable and Wireless, had drawn attention to the need for site surveys. The consultee suggested the right to survey was implicit in the old code rights. So that consultee hadn't even noticed it was express, but requested a standalone right be provided for. Another consultee also suggested the old code was deficient in failing to provide a right. So nobody noticed this thing. And what we do know is that the power is firmly in the context of, but we accept is not limited to, compulsory purchase powers. And therefore it's about the possibility in due course of the operator buying the land outright.
Why do you say that?
Because it's in the context of compulsory purchase.
Well, the heading is
Yeah.
is
The heading.
Can we just look at it?
Yeah. There's another big point which we've not looked at, which I'm going to come to.
Let's actually have a look at the terms of it.
Right.
So you have what you haven't got, unfortunately. You haven't got the heading of the schedule. You've got the actual the paragraphs, but there's no heading to the schedule. The schedule itself, as I recall, is heading compulsory purchase and rights of entry.
Yes, so we've seen that the enabling provision is 118, which is headed compulsory purchase of land, etc. Yeah? And the heading is compulsory purchase and entry for exploratory purposes. So they're together because that's the context. Now, there are four important differences between this and the code, only one of which you've been referred to. The first one is this doesn't apply to us. My client, well, not just because it's not buildings. A code operator is defined right at the top under paragraph 1 as a provider of an electronic communications network, in whose case the Electronic Communications Code is applied by direction under 106. We are owned by Vodafone and O2, Telefonica as it's now called, but we are not providing a network. We are infrastructure providers. We come under the code by reason of paragraph 4b of the code, but we don't have the benefit of this right. So the code is adapted for our position, but this schedule is not. Schedule 4 is not available to us, and Cornerstone's code direction under section 106 is not for an electronic communications network, but for a conduit system, which is also known as an infrastructure system. The second thing to note...
I'm afraid I've lost schedule 4. Is it in tab 17?
No, it's now back... It's
So it's in supplementary.
yeah. What happened was the bundles were prepared and put in this new tree without the relevant bit actually in. So it was added in yesterday, and it's behind tab 1 of the orange and black file. So, my lord,
I'm afraid I've been trailing. So
you've been trailing, but
you've taken us to
definition of code operator.
code operator, right?
Yeah.
Thank
It means a provider of an electronic communications network. That's not us. We have the benefit of the code because of paragraph 4b, but because we okay, great. Next thing to notice, Schedule 4, paragraph 6b. A person nominated by a code operator and duly authorised in writing by the Secretary of State may enter upon and survey land. So this requires the Secretary of State's permission being given to the person nominated by the operator, which is pretty cumbersome. And there are four things to notice about that. The first is, it can't have been intended to apply to our situation where the code is meant to make things quicker and cheaper for operators, because every time we want to survey a site, we've got to go to the Secretary of State. Second of all, Why is the Secretary of State's consent needed? Only answer we can think of is because this is a CPO situation. This is in the context of permanent requisitions of people's land. What we're talking about is a few men and women in high-vis jackets having a look for a couple of hours on a Wednesday afternoon to see whether this site in Paddington is going to be suitable, policed not by the Secretary of State, but by the Tribunal, which has expressed the wish to do with paragraph 26 applications on paper because the test is relatively low.
Is there no explanation for either in Hansard or in any government pre-legislative material about these provisions?
There's absolutely nothing in the explanatory notes.
Well, where does it say? This comes from somewhere else, does it? Where does it originate?
This originates, I think, in the 1984 Telecommunications Act.
It's in the Telecommunications Act, and is it in exactly the same form?
Yeah, it's not been changed.
It's not been changed at all.
It's been slightly redrafted. We've got section 37 of the 84 Act, which we've got at tab 15.
Right, it's not been substantially changed. My Lord, so the first, I said there were four differences. The first one is this doesn't apply to us. The second is that you've got to have authority in writing from the Secretary of State. And I was just exploring what that means, because the duties which the Secretary of State has to have regard to are very different from the test under paragraph 21. If your Lordship...
Sorry, I'm sorry, I just want to pursue this a little bit. So the origin of what is now paragraph 6, is this right, is section 37.
Yeah.
But section 37, I see, is in part 2. Where was... That obviously isn't preceded by anything about compulsory purchase. It looks as though it's freestanding.
Well, the enabling... Paragraph 118 is the enabling provision. Sorry, section 118 is the enabling...
No, I know that. I'm just trying to go back. I'm trying to see where this has come from. It was originally the Telecommunications Act 1984. Are you able to tell me whether or not the other provisions that are now in Schedule 4 were in the 1984 Act, and if so, where were they?
Not off the top of my head. Well, can I continue exploring this, just to show you, because there's much more on this, which makes it clear that this is for a much wider communications context than ours. If we look at paragraph 2, you can see what duties the Secretary of State is directed to have regard to when deciding whether to authorise somebody to use these rights. In exercising his powers under this schedule, it's the duty of the Secretary of State to have regard in particular to each of the following.
Where are you reading from?
Section 2. Paragraph 2 of Schedule 4.
Paragraph 2 of Schedule. Sorry. Which tab are we in now?
We're now in the black and orange file. Yes. Tab 1. Paragraph 2.
Parity. Yes.
Now, we've seen that the Secretary of State must authorise. So it's not just a matter of going to the upper tribunal. And then it provides, in exercising his powers under this schedule, it's the duty of the Secretary of State to have regard, in particular, to each of the following. The first is the duties imposed on Ofcom by sections 3 and 4. Now, sections 3 and 4 of the Communications Act 2003 are not in the bundle, but there's a very long list of things that the Secretary of State must have regard to under paragraph 3 and 4, including things like the desirability of preventing crime and disorder and the different interests of persons of different ethnic communities. What's this about? This is really about TV and internet. This is about content, because much of the Communications Act 2003 was about content. So the first thing, the duties imposed by section 3 and 4, none of it really relates to our situation. B, the Secretary of State should have regard to the need to protect the environment and conserve natural beauty. C, we need to ensure highways are not damaged or obstructed. This is a completely different test, completely different words to the test under paragraph 21 as reduced to a good arguable case under paragraph 26. And what we say about this is it just makes no sense to imagine that Parliament really intended the upper tribunal to have powers to allow workers to go up there with hammers and nails and saws and drills. But when it came to just having a look, the Secretary of State had to authorise it. Because that is the logical extension, logical consequence of my learned friend's argument. So the second big difference is that the first is it doesn't apply to us. The second is you've got to have Secretary of State authorisation relating to wholly different factors. And we say this is just an anomaly. The fact is the code stands together as a comprehensive code under Schedule 3A, and it's meant to be operative by operators in this type of situation, and this right just happens to have fallen in as a schedule to the Communications Act, which is and relates to completely different things. The third thing, of course, is as we see, this only applies to bare land. It doesn't apply to buildings. So it doesn't apply to land covered by buildings or used as a garden or pleasure ground. That's 6.2. So my learned friend points out, well, only 4,000 are rooftops, but many more would be gardens or pleasure grounds. So that's not really a fair statistic. The fact is that this only applies really to fields. Our situation, it doesn't apply to. And the fourth difference is we're not talking in this case about anything remotely like CPO. We're talking in this case about an MSV. A CPO is a permanent deprivation of rights, and therefore it's not surprising that the Secretary of State's authorisation is needed. My Lord Justice Lewison asked a question earlier today about why is the upper tribunal's imprimatur necessary for paragraph 26 and 27? To which one cheekily responds in this context, so as not to bother the Secretary of State. Because otherwise, it's going to be the Secretary of State, not an official, the Secretary of State, that's got to authorise the MSV. It's absurd. And my Lord, we ask you Lordships to reach the same...
The Secretary of State can't possibly be the Secretary of State personally.
Well, my Lord, we can't find anything that says it can be delegated.
Well, it's the Cartonian principle that the Secretary of State can delegate to his officials.
Well, we can't find examples that are being used. We can't find anything on this. It's the great mysterious schedule. My Lord, what we say is that this schedule is not fit for our statutory purposes. It's not fit for us. It's not fit for this land. It's outside the structure of the code. It involves the Secretary of State. And what the Deputy President said, we say, is perfectly sensible, which is the fact that there is a different right in a different context to do a similar thing doesn't detract from the scope of the right under paragraph 26. My Lord, there are other rights of entry that my learned friend referenced in his skeleton, but he hasn't mentioned them today. I won't go into them. They're dealt with in the skeleton. One of them is just between operators, which doesn't apply. One's between operators and public authorities, which is quite different. I need to move to issue 2, because we want to finish today, I assume.
Of course. If you're right on issue 1,
Yeah.
what you want is a code right.
Yes.
And you could ask that under paragraph 20, I take it. You would accept that? We could do, but we don't want to. No, so necessarily you say that if you want a code right, you have a choice, either going under paragraph 20 or under paragraph 26.
Yeah. But we'll go under paragraph 26 for genuine interim rights, for music festivals and the like. And I'll explain in a minute why that's in everybody's interest, because when there's a royal wedding on in Windsor and the number of visitors to Windsor triples over the weekend 4 times, we don't want a situation, and nor does the landowner want a situation where we have to give 18 months notice and we have security of tenure. That's the type of situation interim rights are for. So for all genuine interim situations, we'll go under paragraph 26. So
What makes it interim?
it's the definition of interim under paragraph 26 is what makes it interim. 26.2. What makes it interim if it's for a period or until the occurrence of an event specified in the order.
Why isn't that covered by 23.7?
Because that's about paragraph 20.
Well, yes it is, but paragraph 26 4C applies it to paragraph 26.
It does. It's true there is an overlap. It's true there is an overlap, but this is 23.7 that doesn't refer to events. This is
Well, surely an agreement under paragraph 27 could say this right is exercisable until the conclusion of the royal wedding at Windsor.
My lord, let me approach it in this way. There are many examples where you don't need or want a paragraph 20 and will only want interim rights. I'll give your lordship two examples. The first example is where there's an interim need for a new site, and that's happened here with the McCure Hotel. The McCure Hotel is what we're using at the moment, but it's not going to last because that's going to be redeveloped. And what the jargon in the industry for that is called a temp site. So it's another site next door, nearby, to which we can move whilst development works are being carried out on the main site. So this is not lift and shift. This is where we want to use, let me come at it again. We have a site. Our site, the roof is being recovered. So we go next door for an interim period called a temp site. We use a site temporarily. We don't need, and the landowner will not want us to have security of tenure over that temporary site. Paragraph 26 is perfect for this. It's a time or event limited interim right over the temp site that can be granted by the upper tribunal, which can be enforced by immediate removal of notices under part 6. And those interim rights are rights which you'd never need replicated in a final agreement under paragraph 20, because you'll never need a permanent agreement on the temp site. There's another example is for a festival or the royal wedding. If my learned friend is correct, then even for an urgent one-off application, we'd need to issue a paragraph 20 application purporting to seek a permanent right, even though we know that the royal wedding extra demand is only over a couple of days. It's a complete waste of time and money to issue that paragraph 20 application. This whole process is supposed to reduce costs. And, my lord, the idea of making and then withdrawing a paragraph 20 application, which we never seriously intend to prosecute, is wasteful and unnecessary. The paragraph 20 notice is long and it has to annex a long agreement with it. The draft agreement's long. The issue of proceedings is expensive, it's time consuming. There could be a costs and case management hearing before we can withdraw it. Directions, witness statements, disclosure. Complete waste of time.
But your paragraph 26 application must be preceded by a notice complying with paragraph 22,
Yep.
and that requires all the terms of the agreement. So there's no saving of times there in terms of what goes in the notice.
My lord, there is, because it must comply with 20 brackets too. That means tick the boxes off. So we need to look at what the boxes are in 22. We have to set out the code rights and all the other terms of the agreement that the operator seeks. So this would just be a one-page thing saying we want the opportunity to inspect the rooftop for 2 hours on 3 afternoons.
Well, the point I'm putting to you is it's exactly the same whether you apply under paragraph 20 or under paragraph 26, so that there's no saving in that respect going under paragraph 26 because you do the same thing under paragraph 20. We want to go on the roof for 3 hours and 1 day in November, whatever it is.
My Lord, my learned friend suggesting we don't just have to serve the notice, we then have to follow up with an application under paragraph 20.
Yes, but only for the MSV that you're seeking.
Well, yes, but we have to trigger the whole litigation process under paragraph 20, seeking rights which we don't want, and the site provider doesn't want us to have, namely security of tenure. Once we go under paragraph 20, we are looking at a situation where there is a statutory continuation, where notice can only be served of 18 months or more. That's just not suitable. This is what this is for. And what my learned friend's argument is driving us to go through a pretense in terms of paragraph 20 to achieve a result that can be equally well achieved without that pretense having been gone through.
So can I just paraphrase the argument you've just put and see if you agree? What you're saying is that if you consider the purposes for which the code is intended, there is an objective and manifest need for what, absent the wording that's found in the code, might be called temporary arrangements. In fact, when we look at the code, we find that paragraph 27, which is directed to temporary arrangements, isn't suitable for that purpose, whereas paragraph 26, which uses the wording interim, actually is suitable for that purpose. Is that what you're saying?
Absolutely, my lord. The naming of these two rights is not the happiest.
Yeah.
Absolutely so. Can we spend a few moments just looking at the big differences between 26 and 27? The first big difference is that 26 is for two situations, both where the apparatus is already on the land and also where the apparatus is not already on the land. There's nothing in 26 which excludes either situation. In 27, the apparatus has to be already on the land. That reference, 27, subsection 1b, must be already installed on the land. Next big difference. The length of the right under 26 is defined in 26.2 as the period or event specified in the order. So interim has a specific definition, whereas the length of a temporary code right is until the proceedings under paragraph 20 or 40 are determined. Reference 27 subsection 3. So there's no doubt that 27.3 does expressly require an accompanying paragraph 20 application in a way that paragraph 26 doesn't.
Hang on. 27.3.
So first difference is 27 is only where the apparatus is already installed. 26 is for both situations, where it is and it isn't. Second big difference, the length under 26 is as per 26 subsection 2, whereas under 20...
One minute, right, so let's start at the end, that's the last point.
Sorry.
The current point you're making.
Length. The length of an interim code right is as per 26 subsection 2.
No, you dealt with that point.
Yeah. And the length of a 27 is until the proceedings under paragraph...
I got that point. I thought you were getting on to another point.
Yeah, I was saying paragraph 27 doesn't expressly require...
And 27 talks of a notice under paragraph
Yep.
22,
Yep.
whereas 26 talks of one which complies with 22.
Yeah. Yeah, that's different. Complies means tick the boxes. It's not a notice as such under paragraph 20. It's one which ticks the boxes of 20 subsection 2. It just has those features. Whereas under 27, the notice under 20 subsection 2 is assumed to have been made and proceedings are on foot. 27.3 is the key, because 27.3 shows you that the occasion for claiming a paragraph 27 right only arises if you do it with a proper paragraph 20 claim for permanent rights.
So where is the under point in 27? These under.
27
1A,
1A, yeah.
where an operator gives a notice
Under.
paragraph 20.
And that contrasts with complies with, which is more of a tick box word, which is under paragraph 26.
26.3, yes.
Yeah, third line, yeah. So,
What you're particularly emphasising, though, is 27.3.
27.3, yeah.
Yeah,
That,
that you say is explicitly envisaging the order being made until the proceedings under paragraph 20 are determined.
Yeah.
We find no such reference in 26.
the Deputy President used the words nothing remotely comparable
Yeah.
in 26. So basically, 20 and 27 go together, like Derby and Joe. There's no such thing as a standalone paragraph 27, but there can be a standalone paragraph 26, we say. So the question arises, what's the reason for the different treatment of 27? The reason is they have actually different purposes. Paragraph 27 fills the gap where the apparatus is on site, but it's unsupported by any code rights. So, maybe the operator's a licensee whose term has expired, or for one reason or another is under threat of Part 6 removal of apparatus proceedings. Paragraph 27 gives rights to allow the operator to hold the line until it can get its paragraph 20 application for full permanent rights heard. It's a bridge. Paragraph 27 is a bridge to regularising the standing of the operator under paragraph 20. In contrast to that, paragraph 26 gets the operator...
Has the installation got on the site?
Well, it's already there under some previous right, under an old code right,
It's under some old code.
under tenancy. Yeah, but 27 only applies.
Granted by an occupier and not binding on a landowner with an interest higher up the chain, for instance.
Yeah, it could be there for a variety of situations. It's already there. Maybe the rights to be there has expired and they're there holding over, or as a trespass or whatever. Paragraph 27 allows the operator to hold the line where it's got no code rights until it can get its full paragraph 20 application heard. Paragraph 26, different. It gets the operator a code right for a specific limited period or for a specific limited purpose, but it could be any code purpose. It could be a need to lop where there's existing apparatus, or a need to temporarily upgrade power where there's a music festival. Paragraph 27 gets you rights just for one purpose, while you wait for your paragraph 20 claim to be heard. Whereas 26 can get you rights for all sorts of purposes, code purposes. And what my learned friend is doing is asking you to read 27.3 into 26. 27 subsection 3 into paragraph 26. And he needs a good reason a good basis to ask you to do that. And in fact, there is no good reason. And there's no good reason because the answer to every single point he makes in this context is that the Tribunal has got jurisdiction under paragraph 26 and has a discretion under 26.3, which we can take it will exercise judicially. That is the answer to so many of his points. Lord, I would like to show you, Lordship, something else, which is really subtle, but...
Sorry to interrupt you. One of the big points you've been making is that if you get rights under 26, you don't get security of tenure.
Yes.
Which you get the right imposed under paragraph 20.
Correct. 30 subsection 3.
Is that the explanation for the difference between the good arguable case test for getting a right with no security as opposed to a full-blown test which you are required to satisfy to get the same right with security? Is that the reason for the difference?
It could be.
I mean, otherwise it's odd. There are two different tests and that the operator can quite deliberately choose the lower test in preference to the higher test.
Yeah. Maybe, because he's not going to get his security. Because of...
I think because the whole 26 proceeds on the basis for a limited period and then finishes.
Yeah.
That's the whole basis of 26.
Yeah.
So that would suggest that that's a reason why.
That could be a reason why. Because
I mean, that's consistent.
the protection given under Part 5 And also Part 6, which allows the operator to resist the removal of its apparatus. It's pretty extensive. And the 18-month period, it's a long time. So that may be an
So if
explanation.
you look at 33, it deals with both 26 and 27.
Yeah.
So presumably you don't need paragraphs under 27 because, as you say, you need to have a paragraph 20 application.
Yeah, you do.
So that will be conferred on you if and when
Yeah.
the paragraph 20 application is determined. And 26, you say you don't need it because it's temporary
Yeah.
and it's never going to be permanent. That's the nature of the application
Yeah.
that you're making.
Yeah. I mean, this won't help your lordships, but it would have been much easier if the title to 26 and 27 had been reversed, and 26 had been called temporary, and 27 had been called interim, but that doesn't matter now. We'll have to live with it. Well, Lord, I wonder if I could show you something else. This is a subtle but potentially knockout point. There are circumstances envisaged by the code where it won't be possible to fulfil the alleged mandatory requirement alleged by my learned friend for proceedings under paragraph 20 at the same time as seeking interim rights under paragraph 26. And the argument is this. Under paragraph 20 subsection 3a, you can only issue a paragraph 20 application after there's been 28 days of no agreement. If you look at 26.5, 26 subsection 5, you see that the tribunal can abridge time under paragraph 26 in a case of urgency. So the tribunal can make an order under paragraph 26 even if the 28 days hasn't elapsed. 26 subsection 5 disapplies the need to wait for the 28 days, which is given to the landowner by paragraph 20 subsection 3a to decide whether it wishes to agree or object. So, you may be in a situation where you can't possibly have issued your paragraph 20 application as at the date that the paragraph 26 application can be issued. There's a time lag. The code says the tribunal can make a paragraph 26 order even though the paragraph 28 days hasn't expired, but it doesn't allow for abridgment of that 28 days. So the two notices won't necessarily be simultaneous in all circumstances because you can do the 26 before the 28 days has elapsed. And that is a code-based objection to my learned friend's submission that 26 is parasitic on 20 and they must be brought together. But that's a bit technical.
There's a parenthesis, and paragraph 23b does not apply. The court may make an order in this paragraph, even though the period mentioned in paragraph 23a has not elapsed. You dealt with that.
Yeah.
This is brackets, and paragraph 23b does not apply. And 23b is...
That's because even if the relevant person does agree, you've still got to go through the arbitration.
Correct. Absolutely. But there is a code-based reason for seeing that these two notices might not be simultaneous. The code itself suggests a situation in which they may come apart temporarily. Well, can I just go back to common sense a bit? The learned friend's argument this afternoon was that a final hearing is necessary for costs or because it may be necessary to decide on whether the paragraph 26 ought to have been made in the first place. That was his point. And we genuinely don't get that, because a paragraph 20 hearing for final permanent rights is not ever going to be a reconsideration of whether a paragraph 26 order ought to have been granted. It's about whether full paragraph 20 rights should be imposed. That's what it's about. It won't in any situation look back on whether the, quotes, interim injunction ought to have been granted. That's done and dusted. The way that this code works is that the decision about paragraph 26 is made by the tribunal in accordance with its rules, and it said it will do it on paper, and that's that. Nobody, and the full paragraph 20 will look back to that. A full paragraph 20 looks forward. And the whole thing's ridiculous. We only want a survey. How can an operator who doesn't have apparatus on site, like our situation in relation to this building, define what code rights we should seek without a survey? Without a survey, we don't know anything. We don't know if we need to connect to a power supply. We don't know if we need to look at trees. Mullin and Friends' argument makes us have to do a full paragraph 20 application on the basis of a punt in the dark without knowing whether it's feasible if we get to the site.
When you say full paragraph 20 application, he is saying you need to make a paragraph 20 application for the MSB. He's not saying you need to make a paragraph 20 application for the actual installation of apparatus.
So he's saying we've got to do it in two stages?
He says you've got to do it
Twice.
Yes.
Right. Whereas I say, once is enough if this site turns out not to be suitable.
Can you help me on this point? I'm a little bit confused about the indications and all this. As I understand it, under 20, starting position is that if everybody agrees, you don't need to go to the tribunal.
Yes.
That's the starting position. The next point is that under 26, you whatever happens, you have to go to court.
Yes.
You have to go to the tribunal.
Yes, to stamp it.
To stamp it. Now, Mr. Clark says that if you do make that interim application, then whether or not you've made an agreement about the rest of it, you have to go to the tribunal in order to so that there's a further hearing to which the site owner is entitled in order to see whether or not, applying the different test in 21, that should have been given. All right, but that's what I'm trying to understand.
Why would one
So is the effect of that whenever, although you can have final rights granted without going to the tribunal, the moment you ask, on his argument, the moment that you ask for an interim, or you want an interim right, then you're compelled to go to court for the full as it were, for the full hearing.
That's what he says.
That's what he says.
So that can't be right. Can't be right. Why? There's no purpose. There's no purpose to having. There's no purpose to making 26 parasitic on 20. I mean, it's not just that there's no equivalent of 27.3. It's the fact that there's no purpose of it. Where does it get anybody? What's the purpose of this extra hearing? We've done, as my Lord Justice Lewison said, we've done the survey. By the time we get to the paragraph 20, it's done and dusted. We've had the right. What's it for? I don't get it.
There's one other linguistic point I'd like to put to you, if I may, Mr. Seeker. Section, as paragraph 26(3)(b). The good arguable case is not simply that the test in paragraph 21 is met, which it might be. It's the test in paragraph 21 for the making of an order under paragraph 20. We could simply have said, well, what you've got to do is satisfy the first condition and the second condition in paragraph 21, subject to paragraph 5.
Yeah.
Why has it got for the making of an order under paragraph 20, rather than simply saying, well, that's the test, that's your good arguable case standard?
Because there's a discretion one under paragraph 20. If they'd have said under 3B, the court thinks there's a good arguable case that the first condition and the second condition are satisfied, you wouldn't have imported the discretion in the word may in 21 subsection 1. They want to import the discretion.
So even if the court is satisfied that this test is met, it can say, well, we're not going to make an order.
Well, that's an argument for that may be an argument for a different day. But in terms of your Lordship's question, which is why did they use the words for the making of an order, the only thing I can think of is that they, as opposed to saying first condition or second condition, they wanted to import the whole of 21. And of course, 21 also has 4 in it,
Yeah.
which is a gloss on 3, and also 5, which is a gloss on the whole lot. So maybe they wanted to bring that into account as well as the discretion, and say it's the same test, but just on a lower hurdle. It's the same bar, but it's just been moved down a couple of notches. So, my Lord, what we do say is we just can't see why Parliament would have wanted my learned friend's arguments to be correct and to force us, when we're going under paragraph 26, for an interim right to cover a specific event, a music festival or the like, to have to make a full paragraph 20 application when nobody would possibly want it. And the Ofcom notices reflect that. Under paragraph 90 of the code, there's an obligation, under paragraph 90 subsection 1, there's an obligation on Ofcom to prescribe a form of notice, must prescribe a form of notice.
Sorry, where is this?
Paragraph 90 of the code.
Thank you.
And then in paragraph 88, subsection 2, we see that if Ofcom have prescribed the form of a notice, which may or must be given by an operator, the notice given by an operator under that provision must be in that form. So this is pretty strict. What 88 and 90 are saying together is that Ofcom must make statutory notices, and you must comply with those statutory notices. And the significance of that, the notices themselves are behind tab 30 of the authorities bundle, but the significance of it is that paragraph 26 rights can be sought on their own under a prescribed Ofcom notice, but paragraph 27 rights can only be sought within a notice also seeking final rights under paragraph 20. It may be worth, I'm trying to finish this by 4:15, self-imposed deadline, so we can finish today. But it's behind tab 30, and one of the authorities bundle, what it shows is that 20 and 27 always go together in the required notice. And this is not just, oh yes, as I've shown you, this is not just some legal publishing company making money out of notices. These are the notices that have to be used. The first one shows that a notice under 22 and 27 go together, and then the notice a few pages on, at the end of that, is a standalone notice under paragraph 26.3. So the Ofcom notices reflect our approach, and those are the ones that have to be used. Well, I could go on for ages about this. I know nobody really wants me to, but the short answer to what my learned friend says, that without a full paragraph 20 hearing, we can sidestep the public benefit test, the full-blown public benefit test, or we can make multiple paragraph 26 applications. The answer to all that is that the Tribunal will supervise with its discretion. The Tribunal will not allow us to make multiple paragraph 26 applications. It's going to say, hang on, you've done this before twice already. You're trying to get round the full-blown paragraph 20 with its higher bar. So I'm only going to give you another 2 weeks with your interim right unless you issue a full paragraph 20. The Tribunal is perfectly capable in its discretion of managing any sort of abuse that my learned friend can think of under its discretion in paragraph 26. My Lord, I don't know whether it's going to... I want to stop at 15:15 so that we can finish today.
Thank you very much. Thank you, Mr. Yes, my Lords, I do have just a few points, if I may. The first is a point of admin, really. Your Lordship asked whether there was an automatic right of withdrawal.
Yes.
in relation to tribunals. The Tribunal Procedure, Upper Tribunal Lands Chamber Rules 2010 as amended. Rule 20, you're able to withdraw proceedings. But by Rule 20 Sub-Rule 2, you need the Tribunal's consent unless Rule 20 Sub-Rule 3, it's a permission to appeal application that you're withdrawing, or all parties consent. So that's the point on that.
What is that? It's the tribunal.
The Tribunal Procedure, open brackets, Upper Tribunal, close brackets, open brackets, Lands Chamber, close brackets, Rules 2010 as amended. They have been amended, I think, in 2014. The second point I wanted to mention, because I had never heard of a figure of £30,000 to £60,000, having been involved in this case.
It's not in the upper tribunal.
The Upper Tribunal evidence is actually referred to by the learned deputy was that we were asking for £400 per visit. That is in the judgment. I will give you the reference for that. That's paragraph 126 of the judgment. The notice that was served sought £50, was asking or seeking to impose the agreement for a £50 fee, and we asked for £400 per visit, para 126. So 30 to 60,000, I don't know where that came from. The next point I wish to make is in relation to paragraph 6 of Schedule 4. My learned friend dealt with that at some length.
Yes.
The first he said he doesn't apply to us. We're not a code operator within the definition. There is a case which we don't have called CTIL and Keast, where there was some discussion about the limitation on what was CTIL's direction under Section 106 of the Communications Act. They simply had a direction prior to the coming into force of the new code to a conduit system. The question was whether or not they could take advantage of the code, and the answer was yes, they could. I don't have the case here. Whether or not it was because they were then treated as a code operator or as an infrastructure provider, I cannot recall. Obviously, there's an important difference there. If they were treated as an infrastructure provider, they're still not a code network operator. But there is some discussion about the limitation that was made on CTL's direction under 106 and a
So
determined...
I thought I asked you when you opened the appeal whether we were paragraph
Yes, they are.
4B case or...
Yes, they are an operator. They are an well, they are treated, yes, my lord, they are treated as having code rights. I recall that the limitation was on a conduits system. That was their pre-code direction. Keast has treated them as being code protected. I suspect, I cannot recall because I don't have the case before me, it was because they were an infrastructure provider treated as such under the new code. How that result was achieved, I do not know.
If that's right, then they would not qualify.
They
under
would not
Schedule
qualify, I
4.
accept that. But of course, that's CTIL.
Yeah.
That is not every other network provider. And of course, as I understand my learned friend's submissions, I made a note that he accepted that the terms of paragraph 6 of Schedule 4 were not limited to compulsory purchase. That's the line I noted. Except no limitation to compulsory purchase. What he made, his emphasis was, well, it doesn't apply to us, thank you very much. Well, that's all well and good. It may not apply to CTIL, but it is a pre-existing piece of legislation which, according to the respondent, accepts is not limited to compulsory purchase, which applies to network operators.
Your main point on this still is, I understand it, here was a precedent which the draftsman could have
Yes.
adapted
Yes, that's
to
right.
the circumstances of the code, so the precise limitations of Schedule 6, Schedule 4, paragraph 6 don't really matter.
That's right, my lord.
It's there as a
That is
precedent.
right. That is right. Then there were a number of points about paragraph 26 and 27. The first thing on paragraph 27 is that there are a number of preconditions to 27 that are applied. And as my learned friend says, it's as it were, a stay on removal. So one did have a code agreement. The code agreement has expired. There has been an opportunity to serve a paragraph 40 notice, that is to say, to seek removal. And then you seek protection. It is also worth noting, before we look again at paragraph 27, the terms of paragraph 40, sub-paragraph 8. This is a restriction on the ability to seek removal of ECA. So the landowner will not obtain an order for removal, or for, if he has obtained such an order that in default he can sell. He doesn't obtain one of 6 or 7. If an application under paragraph 23 has been made in relation to the apparatus and has not been determined. So the terms of paragraph 27 are predicated on the stay being sought to be implemented by the operator, because we see when we go back to paragraph 27 that one of the conditions, subparagraph C of paragraph 1, is and the person has the right to require removal. Under 37, that's to serve a notice requiring removal, or has mentioned in paragraph 41, but the operator is not for the time being required to remove the apparatus.
This would also apply, would it not, to an application under paragraph 26. So if you were to apply under paragraph 26, you get your interim right. It then expires, let us suppose.
Yes.
That means that the landowner can go under part 6, but if in the meantime the operator has made an application under section 20,
It stops it.
then it stops.
It stops it. That is right. And that is one of the points we seek to rely upon, which is the perhaps pejoratively referred to as the manipulation of the code. But that is what one can do.
I'm just trying to understand.
I'm sorry, my lord. So
You
What-
referred to paragraph 40 subsection
Yes.
subparagraph 8. And the point you're making there is that this is
this is in to
this
stop
is enforcement
removal.
of removal
Yes.
of apparatus. That's the whole
Yeah. So you can stop.
test. And
The operator can
6
stop
is,
it.
hang on. 6 is here the landowner occupies giving notice to the operator requiring to remove the apparatus. That's the context for this.
Yes, that is right, my lord.
And then 6 is gives a notice, and then if they don't reach agreement, that's 5. Then 6 is where there's an application to the court by either of them. And then it says on an application under 6 or 7, the court may not make an order in relation to apparatus if an application under 23 has been made in relation to the apparatus has not been determined. So here, as I understand it, the context is the landowner's asking for removal, they've not reached agreement on it, and one or other of them then applies to the court. If an application has been made under 23, then it can't be removed in the interim.
That's right.
How is this helping anybody?
That is because it ties in with paragraph 27.
Right?
Because paragraph 27, subparagraph 1c, talks about you have to have given notice under paragraph 20, subparagraph 2, in respect of the land.
Yes.
And so that
What's
you've triggered your paragraph 20. Yes. So tying that in with paragraph 40, subparagraph 8. Subparagraph 48 requires you to have made your application. You can only make your application if you served a paragraph 22 notice.
Right.
Yes, so they are
It's not
intimately connected. What I'm trying to get at, my lord, is that the point of paragraph 27 is that it is part and parcel of the stay with respect to removal of apparatus. And the reason why one finds a reference to paragraph 20 is because what the operator is doing is he's seeking to stay removal per paragraph 40, subparagraph 8.
He may be doing it. Yes, I mean, this could arise under a whole series of situations where, as you say, the agreement may have run out under some previous arrangement. Nobody's requiring it to be removed at the moment, but they haven't reached agreement to the terms on which it should stay.
There are three conditions, A, B and C.
Yes.
Paragraph 27.1.
Right. Yes.
So I
You're envisaging that somebody is saying it has to be removed. It may not be at that stage. It may simply be they can't agree with the terms which are staying.
It may be that there has to be an entitlement to seek removal. That's the
The only point that the only point Mr. Seatler was making was that 27 only applies or is limited by. It envisages that there is a paragraph 20 application. That's the only point he's making.
And the point
whereas
Yeah.
26 does not require that. That's the only point he was making.
Well, the only point I was trying to make is that under 27 we have specific reference to 20, and as I see it, as I read the code, that ties in with 40 subparagraph 8 because
That's one of the circumstances.
that's one of the circumstances. But that is why one sees the reference to paragraph 20 because you're envisaging two sets of proceedings. There may be a paragraph 20, there may be a paragraph 40. Subparagraph 3 is referring to the dichotomy.
I don't see personally at the moment how that advances the matter. I mean, there could have been a specific reference under 26. That's the only point Mr. Seat was making, rightly or wrongly. There could have been an express reference under 26 with a reference to paragraph 20.
Well, we submit there is because there are 2 points which Mr. Ziegler hasn't dealt with. The first is paragraph 26, subparagraph 6. He hasn't explained why it is that the consideration is only a power. That is, as I've submitted, consistent with it being parasitic, a pending claim. Nor has he dealt with paragraph 26, subparagraph 7, which refers to without an agreement relating to the code right having been imposed. Now what? Subparagraph 7, my lord, which is where the specified period or the event has occurred without, in either case, an agreement relating to the code right having been imposed, then subparagraph 8 applies, i.e. you can go straight to part 6.
Yes.
Now, we say the reference in subparagraph 7 to an order under paragraph 20 is because it is premised on the fact that there is a paragraph 20 claim afoot. It doesn't say without an application relating to the code right. Moreover, contrary to what he said when he said, well, of course, at the final hearing we wouldn't be interested in the interim right because it will have already been granted. Subparagraph 7, note the wording. It is an agreement relating to the code right. The code right, which is the subject matter of the interim order. So when he says we're not concerned with the code right because it will already have been the subject matter of the interim, his submission was, well, paragraph 20 is about something completely different. He said it's nothing to do with the interim right. It is all to do with the interim right because the whole point of subparagraph 7 is you have to have a paragraph 20 afoot in relation to the code right. If the paragraph 20 hasn't been determined relating to the code right, it comes to an end. But the premise of subparagraph 7 is that there is a paragraph 20 in relation to the code right, is to the code right. In relation to notices, he made reference to the Ofcom notice. We submit that trying to interpret the statute by reference to notices produced by a body such as Ofcom is the wrong way to look at it. And, it's their understanding, it may be wrong. For whatever reason, they've decided upon 2 sets of notices in that way. And then he made a point about paragraph 26, subparagraph 5, about the fact that you may have an application under paragraph 26 without necessarily a reference under paragraph 20. Of course, you will have had to have served your paragraph 20 notice because that's what you're required. Paragraph 26, subparagraph 5 refers to the fact that an order may be made in a case of urgency. That is true. So it is the case that the notices may be simultaneous, but as with the case of an interim injunction being sought before substantive relief is issued, there's nothing stopping that. And of course, as he himself acknowledges, there can be conditions imposed, one of which is that the paragraph 20 reference has to be issued. I mean, you've made the notice, simultaneous notices. His point is you don't need to have simultaneous applications. You can go under paragraph 26 because of subparagraph 5 before you've issued your reference under paragraph 20. That's his point.
You go to court for an injunction requiring the
Well,
operator to comply with that term of the agreement.
it would be a condition that there be an application made if it has not. Subparagraph 2 of 26 provides for an occurrence of an event. It will lapse if that condition is not fulfilled.
But if I don't mind that, I've done my investigation.
Well, that is right. Your interim right will cease, but we'll come back to the point that you would still need to substantiate that, and the site provider should be protected. Protection to the site provider is not simply because he has the automatic right to go under Part 6 per the code as we've seen. He's entitled to say you weren't entitled to it. Moreover, we know, because it's accepted, that paragraph 26 interim rights are not the end of it. There may be repeated applications. One final point on 26. There was a reference. I'm not quite sure what the context was now, but my learned friend. Yes, Your Lordship, Lord Justice Lewison, asked about 26.3b. Why is there a paragraph 20 there? My learned friend made some reference to discretion, and in particular the paragraph 21 test. The court may. That, in fact, the notion that there was a discretion within paragraph 21 and a consideration of the word may was the subject matter of an upper tribunal decision between CTIL and Ashlock and APW, handed down on Friday, where this argument was presented by my learned friend. I appeared on behalf of the site provider, Mr. Ziegler appeared on behalf of the operator, and the Deputy President dealt with that at paragraph 99 of his judgment. As I say, it's handed down on Friday. And we referred to a decision called De Costa against Jamaica, 1990, which essentially says the may is to be treated as, once you satisfy those two conditions, it essentially becomes a compulsion, unless there's very exceptional circumstances. It's not to be treated as discretionary. That's De Costa in Jamaica in the appeal case, his Privy Council decision. And the learned deputy deals with it at paragraph 99. That was handed down on Friday.
What does he say?
Well,
He says he's not going to deal with it today.
well, he didn't say that. What he said, and my junior has managed to find a quotation, which is all I need to say therefore, is that it's not obvious to me that the tribunal could refuse to impose an agreement where the paragraph 21 test is met. But my learned friend says that there's a discretion. That was an argument that he put forward. And all I point out to the court is that was the subject matter of consideration. I don't have the full terms of paragraph 99 here. It was something that was raised during his submission. Yes, it will be, and probably on the Upper Tribunal's website, by the way. All decisions on electronic communications code are there. Yes. Forgive me just for mentioning this. The suggestion from the respondent is that this is all terribly onerous, having to serve paragraph 20 notices, etc. And our paragraph 26 is only going to be a short one-page agreement. That was not the case with the subject site. We had a notice with 3 pages attached to which was an agreement of 7 pages. These are detailed agreements. The notion, furthermore, that it's so onerous is one other notice. A paragraph 20 notice is one other notice to which any agreement that you wish to have is to be attached. Ditto, paragraph 26. there's no material difference in the sense of making it more onerous simply because you need to seek the paragraph 20 claim. My Lord, may I just have a word with my junior? Thank you. My Lord, those are my submissions. Thank you very much.
Could I just ask for your Lordship's note, the question of discretion
Yes.
is dealt with in paragraph 142 of the judgment under appeal. The only other thing to say is that my learned friend raised a new point in reply based on 26.7. I don't know whether your Lordships think it would be useful for me to deal with that. I didn't deal with it first time round, although it's in our skeleton. It's in our responsive skeleton.
Hang on, let's just get...
First of all, deal with that in my submissions.
First one, 142.
Specifically.
142 is
Let's just look at that first before you skate on to another point. This is the 26.3 point.
yeah.
I think that Mr. Clark was dealing with discretion under 20.
Under 21, my learned
21.
friend made
The 21.
There was a question from my Lord Justice Lewison about 26
Yeah.
as to why there was a reference to paragraph 20. Now, I understood my learned friend making reference to the fact that there was a discretion, see paragraph 21. That's how I understood it already.
Okay. Well, the
Actually,
question.
I thought you were dealing with the 20. You made a point about the discretion under 26.3, the conditions that could be imposed, and so on.
The Deputy President's views on discretion are dealt with in paragraph 142 of the judgment under appeal. There has been a subsequent judgment, which we haven't got, where we say he doesn't deal with it, although he makes a preliminary observation.
But that's to do with the discretion, as I understand, in relation to what the 21 test.
Yeah, but it's going to be similar because 26.3 is the same test, but just a lower bar. So that's the first thing. The second thing is, I don't know whether your Lordships would find it useful for me to deal with this 26.7 point. What's said is that in some way 26.7 has within it words that imply a presence of a full paragraph 20 application.
You
Yeah.
dealt with that in your skeleton.
We did. I just want to make sure because I didn't deal with
Just
it.
give me the cross-reference.
Yeah, I think my Lord the Master of the Rolls has got what we say on it, which is that there are other circumstances in which no agreement might have been imposed, such as no paragraph 20 notice having been given at all, or a paragraph 20 notice having been given but no application made, or a consensual agreement for permanent rights entered into between the parties in the absence of a notice or following a notice. But only one of the possibilities is the one posited by my learned friend, which is a notice be given and an application for full rights made. There's nothing in 26.7 that carries with it the inevitability of an application under paragraph 20 having been made. That's all. But my Lord, it is in our responsive skeleton.
Thank you very much. We will consider our judgment in this matter, or judgments in this matter, in the usual way. When you receive the draft, please make suggestions for grammatical and textual corrections only. Please agree a formal order. Any further submissions to be in writing unless we ask for all submissions. Thank you both.
Thank you,
much.
Mark.
All right.